FERPA versus HIPAA. Understanding the differences for higher education institutions. Family Education Rights and Privacy Act FERPA and the Health Insurance Portability and Accountability Act HIPAA are both designed to protect sensitive personal information. When it comes to safeguarding sensitive information, understanding which regulations and laws apply is key. While it is always important for colleges and universities to comply with the various requirements in HIPAA for protecting sensitive information, for most institutions, HIPAA will either not apply at all or will only be applicable for a small subset of areas or services on campus. In this video, we discuss the differences between HIPAA and FERPA and when it applies. We provided links with information on how CampusGuard can help you remain compliant at the end of this video and in the description box. But first, let's take a look at HIPAA and FERPA in more detail. What is HIPAA? HIPAA provides privacy and security for protected health information, or PHI. The HIPAA security rule deals specifically with electronic protected health information, or ePHI. It outlines three categories of security safeguards required for compliance: administrative, physical, and technical. Failure to comply with HIPAA can result in severe consequences and fines. When does HIPAA apply? While HIPAA protects PHI, it does only apply to that information when it is in use by a covered entity. As a general rule, covered entities include: number 1, health plans, including employer-sponsored group health plans, for example, self-funded, self-administered, etc., government and church-sponsored plans, and multi-employer health plans. Number 2, healthcare clearinghouses. And number 3, healthcare providers who electronically transmit health information in connection to billing, payment, and/or insurance coverage, doctors, clinics, dentists, nursing homes, etc. What does this mean for higher education? It is not uncommon for college and university administrators to assume their institution is a covered entity under HIPAA because they have a student health center on campus that provides medical treatment to students, maintains their patient records, and engages in electronic billing transactions. However, the HIPAA privacy rule contains an important exception. It does not apply to health records maintained by an educational institution if those health records meet the definition of education records or treatment records under FERPA. When does FERPA apply? FERPA applies to most public and private post-secondary institutions, all schools receiving funding from the Department of Education, and protects student information, including FERPA education records, records that are number 1, directly related to a student, and number 2, maintained by an educational agency or institution, or by a party acting for the agency or institution. FERPA treatment records, records pertaining to a student who is 18 years of age or older, or is attending an institution of post-secondary education, which are made or maintained by a university physician, psychiatrist, psychologist, or other recognized professional or paraprofessional in connection with the provision of treatment to an eligible student, and are not available to anyone other than persons providing such treatment, except that such records can be personally reviewed by a physician or other appropriate professional of the student's choice. Because student health records at a university health center generally fall within these FERPA definitions, they are therefore exempt from HIPAA. When would HIPAA actually apply to a health center? If a student health center provides medical treatment to non-students, such as staff members, spouses of students, or the community/public, and bills for those services, these medical records relating to such treatment are not within the scope of FERPA, so HIPAA would apply to the protection of these records. Colleges and universities are required to comply with FERPA with respect to the health records of their student patients and with HIPAA for the health records of their non-student patients. What about university hospitals? Will FERPA or HIPAA apply to records for students who are patients at a university hospital? Patient records maintained by a hospital affiliated with a university that is subject to FERPA are not typically education records or treatment records under FERPA, as the university hospitals generally do not provide healthcare services to students on behalf of the educational institution. These hospitals provide such services without any regard to the person's status as a student. Therefore, these records are subject to HIPAA. However, in a situation where a hospital does run the student health clinic on behalf of the university, the student clinic records would again meet the exception and be subject to only FERPA. Can a college or university ask an employee or student for medical information? HIPAA does not regulate the ability of institutions to request medical information from their employees and students for legitimate business reasons. For example, employees may need to provide a doctor's note to a supervisor to validate a sick day or share information with coworkers about a leave of absence to undergo medical treatments. Students may also need to provide medical documentation to validate absences from class or to provide the basis for a request for ADA accommodations. This type of information is not subject to HIPAA. What about medical information for student athletes? It is not uncommon for athletic trainers or physical therapists to operate as if they have an individual obligation to comply with HIPAA whenever he or she receives or views medical information relating to a student athlete. Remember that HIPAA does not apply to medical records that fall within the scope of FERPA. Therefore, HIPAA does not apply to records generated when providing treatment to student athletes. University athletic departments may also provide secondary insurance coverage to student athletes, but the PHI data should be kept and protected by the third-party insurance provider. Once it has been determined that your organization is a HIPAA-covered entity, the next step is to take a deep look at the HIPAA privacy and security rules and determine whether your organization complies. Building technical, administrative, and physical controls into business as usual activities is the best long-range strategy to decrease risk. We strongly recommend consulting with your legal department if there are any questions around what information may be subject to HIPAA. Once you understand what information falls under HIPAA or FERPA, you can verify all required security controls are in place to protect this data from compromise. Need help with HIPAA, FERPA, or a compliance assessment? Reach out to CampusGuard on our website at campusguard.com/contact-us. To learn more about our HIPAA compliance services, visit campusguard.com/HIPAA. To learn more about our FERPA compliance services, visit campusguard.com/FERPA. Learn more about our compliance assessment services by visiting campusguard.com/compliance-assessments. Links found in the description box. For even more resources about HIPAA and FERPA, we provided links to helpful articles in the description box. You can also check out our blog at campusguard.com/insights.